So according to Google, a lot of people are asking if you could sue for a slip and fall accident. Since I've been practicing law for 32 years, I thought I'd take a stab at answering that question. When you're involved in a slip and fall accident, or we'll call it a premises liability claim here in Florida, that means where you're injured on someone else's property. Whether it's a slip and fall, a trip and fall, a box falling on your head, sitting on a bench that collapses, picking up a piece of tile and having other boxes fall down on you because they weren't stacked properly. Anything that you can think of where you get injured on someone else's property, we would call a premises liability claim. So those are claims where insurance adjusters are very thorough in evaluating the case. You have to prove that there was a dangerous condition that had been on the property for a long enough period of time that the folks that own the property or manage the property should have known about it and should have fixed the dangerous condition, or at least warned you about it. If you could prove that, then it may be appropriate to file a lawsuit. Many of these slip and fall cases settle. Sometimes the insurance company says, listen, we understand your client fell on our property, but just because they fell or got hurt or slipped on our property does not automatically make us responsible. They're right. It doesn't. So unless you have some evidence that the condition had been there long enough that they should have known about it, or that maybe they created the condition, then it's difficult to file a lawsuit and go to trial in these cases, because you have to prove to a jury, and it's a misnomer. People say, well, I fell on their property, it's their fault. No. You've got to prove that you fell on the property of someone else because they did something wrong. So, for example, if it's a slip and fall in a food store on a puddle, did the puddle have footprints in it? Did it have cart marks in it? Did it look like other people had been walking through it? If not, you're going to have a difficult case. In the old days, many years ago, you used to be able to prove, well, if they only had 1 or 2 employees doing maintenance in the store, they couldn't possibly clean up spills quick enough, so it's their fault. That's something that the Supreme Court of Florida said we could no longer do. We can't rely on the fact that they have this common procedure or practice of not having enough employees there to clean things up. That's not good enough. You have to show that they actually should have seen that spill had been there for a certain period of time. So in any of these premises liability claims, you have to make sure that your lawyer is aware of what they're going to do to prove that it's the fault of the other party. Just saying, I'm going to sign up your case and send you to a doctor, and waiting until the end of the case and then saying, gee, how are we going to prove how long that water was there? Or how are we going to prove that they did something unreasonable in the way they stacked their shelves that caused this thing to fall on you? You need somebody to address that with you at the beginning. And if your lawyer isn't talking about these issues with you at the beginning, you should be alarmed, because you cannot go to trial on a premises liability claim unless you can prove these things. So those should be the first things that your lawyer discusses with you. If you see some value here, click the like button. If you've got a pending case and you need my help, call me at 877-Gluck-Law. If you've got a pending case and you're not confident that it's being handled properly, you're allowed to switch lawyers if you feel that the lawyer you have is not able to evaluate a premises liability claim properly and to prove fault in a premises liability claim. It's a very difficult area of law, and not all of us have been doing these enough, and I have for 32 years. So again, subscribe to my channel, or click the like button, or call me anytime.